competing legal orders in contestations over land. So the panel will be organized as follows. Rachel Sieder, one of the PIs of the research project, will present as a keynote the content of the project, and then we'll make presentations of each case studies for 6 minutes, please, because we need to keep time. And yes, about the research argument that you are making and the methodological challenges of making the work we are doing. So my name is Ana Braconier de León. I am from Guatemala. I'm based in Ciesas, Mexico. I am part of this project too, and Lara is also part of this project, but she's busy over there. And this is the whole team. So I will ask you to introduce yourself when you will present. And so we will be starting with Rachel and followed by Tatiana, Alfonso, then Ana Cortés, then Jackie Dugard, then Rachel for the case of Guatemala, Namita Wahi, and to finish with Mekonnen. So thank you.
Hello, everyone, and it is wonderful to be back at Bergen Exchanges, and I'm enormously grateful to everybody who makes this huge effort to get us all here to discuss. This project, one of the things that happens with the Bergen Exchanges, alongside the Bergen Exchanges and facilitates the Bergen Exchanges, is the project work that we all do. And so this is a project, PluriLand. We're in the middle of this project. It's supported by the Research Council of Norway. We're a transnational team. We will all introduce ourselves, but my name is Rachel Sieder, and I work at CSS in Mexico City. So PluriLand, what are we trying to do with PluriLand, or what did we promise we would do in trying to theorize conflict and contestation in plural land regimes? A lot of the work that we have done in the projects linked to Law Transform over the years has been asking questions about law and the role of law in social transformation, and we've done it in many different fields of or topics, so lots of work on sexual and reproductive rights, for example, over the years. And we hadn't done a project on land rights claiming. And a lot of us work on land rights in different shapes or forms. So what did we set out? What are we trying to do in this project? We're trying to explain and think about the transformative or non-transformative effects of socio-legal mobilization for land rights for marginalized groups. So, does law matter? How does it matter? Is land rights claiming different somehow to other forms of social and economic rights claiming? So that's one of the kind of big questions that we have for the project, and that we're hoping we will, oops, that disappeared, contribute to, is it going to come back? There, it's back. It's not back here yet. But that we hope we can contribute not just empirical knowledge on the case studies themselves, but also to the broader debates around rights claiming, social and economic rights, and thinking about land. So we have a hugely ambitious brief to have to understand how this works to start, but also to have a cross-regional comparative theory-building exercise as a central part of this project, not just, we hope, a collection of case studies. One of the central concepts that we're working with is land regimes, right? Thinking about socio-legal mobilization in different contexts, and the contexts we're talking about are land regimes. How are we understanding what we mean by land regimes? We're talking about legally plural constellations of norms, range of laws, and sites, different courts and administrative sites that govern patterns of land ownership, access, and use, both legally and extra-legally, right? So we're really trying to build in the plurality of norms and practices that govern land ownership, access, and use. Right? So particularly, for example, Indigenous law over territories, as taking that into account as law, not just constitutional law, administrative law, etc. Legislation, but also thinking about the interplay between the legal and the extra-legal, which is fundamental to thinking about law in general, but particularly to thinking about what happens with land. So we're all, part of what we've been doing for the project is everybody's been developing a snapshot of the land regime for their particular country. And obviously those land regimes are a consequence of long-run historical processes and of how property is understood and defined, rights, and development patterns. Then what we're trying to do is this, right? Analyze the relationships between those land regimes with all of those dimensions and processes of socio-legal mobilization for land rights. What have we been doing? Lots of things. Since we began the project, one of the things we've been doing is shared literature reviews and looking at different bodies of literature that feed into our core questions. So looking at the literature on socio-legal mobilization and particularly on social and economic rights, and asking this question of how is land rights different, right? How is land rights litigation different from, say, health rights litigation? We were talking about this yesterday. So it's different in terms of the object that's being disputed. It's different in terms of the power relations and what land means to power configurations in each of these different land regimes. And it's different because claiming land by marginalized groups in most of the contexts that we're working in means challenging historical and ongoing patterns of colonialism, patterns of macroeconomic development. It might mean putting forward proposals for radical land redistribution, which obviously is politically extremely contentious in most contexts. And it's also about Indigenous claims to sovereignty over territory. And so it involves alternative legal orders over land. Then we're looking at the literature on land and development, which is also huge, and looking at that general and country-specific, particularly the racial, gender, and class dimensions of the politics of land. And then, importantly, we're looking at the literature on property and territorial rights, which is a huge literature. One of the things that is central to some of the thinking that we're doing in the project is about competing understandings and normative regimes and practices over land and territory, right? So issues in some of the cases that the panel will talk about Indigenous and Afro-descendant rights, but also thinking about climate change regimes over land and extractivism and land grabs. So it's been quite a challenge even just to map out the areas that we need to be looking at in the shared literature review. And some of the conceptual and methodological challenges are how much time have I got left, Anna? 10 minutes, okay. I forgot there's the clock, the ticking clock. Okay, one of the things that we've been, as we've met and developed the project, talking about, and I'm not sure that we've completely nailed, but we're getting there, is how to define what transformative socio-legal mobilization about land might be. You know, and Jackie's written a lot about this, about thinking about pro-anti-status quo outcomes. But we also need to ask questions there about transformative according to whose perspectives and according to what kind of timeframes we're thinking about as well, which you know, is a broader debate in the socio-legal literature. And one thing we really want to try and do in the project is not just do normative analysis of the court judgments, but try and look beyond that and think about what the consequences of these complex processes of legal claiming are, right? Even just how you define the temporality of what a land dispute is hugely complex, because you will find that some of the court cases, which is how we normally count temporality, are actually part of very long run processes of claiming and dispute over the same territory. And also thinking about the administrative dimensions of adjudication. So if we just read court judgments and say, well, they're a progressive court judgment because they said A, B, and C, but what actually happens in terms of enforcement? And we've had a huge challenge in terms of limiting what the universe of relevant land rights cases have been. So the panel will talk about their particular cases, but some of us have hundreds of cases we're looking at. Some of us have dozens of cases we're looking at. What we've been doing as a methodological approach or approaches of mixed methods is that we've been building databases of cases. Some members of the panel have been doing this for a very long time before the project, and some of us are doing it as part of the project. We're analyzing case files, we've been doing interviews with litigants and the judges, and then some of us are working collaboratively with land rights organizations who are actually litigating these cases. And then the last thing I'm going to do is present to you, hopefully quickly, our three-stage analytical matrix, right? We've been trying to develop a matrix that we will all do with not necessarily all of the cases, because as I said, some of the countries have hundreds of cases, but selections of cases that we're trying to look at comparatively. That's what we're going to do in the 2 days after the Bergen exchanges as well. So we have this three-stage analytical matrix. The first looks at, is a process tracing tool to look at socio-legal mobilization and the entrenched interests around land rights litigation. Yeah? So you can see the different elements here of socio-legal mobilization. We're looking at grievances. So, you know, what's being violated, but what do the claimants say their injuries are, their demands, right, their claims, the frames. So how are these things legally framed? And we'll talk about that more perhaps in the individual presentations, but we're particularly interested in how those land claims are framed and what has more traction or less traction in different contexts. The decisions, which is also really about the sites, the courts, the jurisdictions, and the rulings, so kind of what court took the case, what was its decision, what was the legal basis for that decision, and then the remedies or the reparations, you know, what's proposed by the courts. And in terms of entrenched interests, we're trying to track who the actors are in these particular cases, so who are the parties to the dispute, who do they represent, and the networks, so where does the leverage come from, and which sectors are mobilized in the different cases. Then, speaking to this question of, is it transformative, or how is it transformative or not, we've been playing with recognition redistribution, so, and a lot of the discussions have been around Nancy Fraser's writing on recognition redistribution, but and protection. So we've been looking at trying to classify, yeah, across that, just in terms of yes, no, but does the outcome of litigation lead to recognition of special status of claimants? So, for example, you know, do Indigenous peoples does the court recognize their right to free, prior and informed consent about, say, a mining project or hydroelectric dam? Does it recognize their specific claims to land, say ancestral land for particular groups? Redistribution, you know, does it actually lead to some redistribution either of the land and the resources, but also of the governance powers over that territory or land, you know, in favor of the claimants? And then rather than, and we've been working quite a bit with some of the writings about social and economic rights that talk about legalization, right? So successful litigation is when it pushes policy, and we don't really see much pushing of policy on land rights litigation. You know, it doesn't. You might win a case to have a stay of execution against the implementation of a mine on Indigenous territory, but that doesn't usually mean that policy changes on extractivism. Right? So we expect to see a lot less traction in terms of legalization, in terms of translation into policy shifts, but does the outcome of litigation lead to the protection of land access, property rights, governance rights of the claimants? That is maybe a kind of different standard from legalization in terms of policy shifts, but that's one that we're working with here. And then the last slide, which is the stage that we're hoping that we can do some more field work for. Oh, this was also a project that kind of started and then COVID happened, so that probably explains why we've sort of front-loaded databases. And to answer some of these questions on diffuse effects, we're going to have to do some more research. But self-governance, does socio-legal mobilization strengthen self-governance or alternative legal orders? Does it amplify marginalized voices in the public sphere? And then lastly, alternative narratives. Are there alternative narratives about land use, land ownership, land development patterns, environmental harm, forms of governance over land that are placed in the public sphere? That, you know, perhaps that's a different standard from thinking about macro policy shift, but we think that that's important in our understanding of diffuse effects of land rights litigation. So I think I've kept in my time. Thank you, and I'll pass back to Anna.
Thank you. Thank you all for being here and for the invitation to the Bergen Exchanges. It's a great pleasure and opportunity to share some results. I'm gonna present and put on the table some of the empirical results that we have for the Colombian case. I'm Tatiana Alfonso. I am from Colombia, but I am based in Mexico. And for this project, I have been working in the case of the PluriLand regimes in Colombia, and what are the processes and outcomes that we can trace in that particular case, in which you probably know that land contestation is a huge topic, and it's also like so closely related to our long armed conflict, and also it's a very, very crucial topic in politics. Well, now that we are actually seeing some policy shifts in the Colombian context for the first time in centuries around land rights. And then, so I'm just gonna use my 5 minutes to show you what we can see in the as patterns in the Colombian context in this around these questions. I have database of the cases that people have brought to the Constitutional Court that is usually regarded as a very progressive activists and so many wonderful things in Colombia, right? And then like you would expect that in land claims, the Constitutional Court behaves very similarly, very similar to in other topics. And we know a lot of things about specific cases in the Colombian context. So what we're trying to do for Colombia in this project is having like a broader explanation in which once you trace patterns, then you can build explanations of why and how it's that's happening. So I guess the first thing that I would just put out for these conversations, for this conversation, is that in terms of actors and frames, it's important to know that in Colombia, we have at least 4 competing regimes in land rights. So we have like the basic regime of the non-agrarian reform, because we never have had a successful one, in which you have peasants as agrarian workers, not as political subjects, because peasants were left out of the Constitution in 1991. And then the Constitution recognized as political subjects indigenous peoples and Black communities, which is the technical term, but peasants were left out, which is like pretty understandable given that peasants are the political actors that in the mind of political elites in Colombia were and are closer to the FARC, to the guerrillas, right? So that's one of the frames. Then we have the multicultural framework that indigenous peoples and Afro-Colombian communities have been using to claim rights, especially the right to land and the territory. And then we had in 2011, the expedition of the Victims' Law that recognized for the first time that there were like important and structural effects on terms of land due to the conflict. That allowed people to use a new frame, just claiming that they are victims of the armed conflict and claim rights based on that. And then we have the restitution land regime. So even though actors can use those, what we can see in the Constitutional Court is that indigenous peoples and Afro-Colombian communities claims the court has been very, very responsive to those in terms of recognition and in terms of redistribution. So the court has granted allocation, protection of the collective territories, which you would think that's counterintuitive because all of those are collective claims, right? So it seems that they're broader. And at the same time, the court has been like so negligent in recognizing peasants' rights for individual cases, so you can see a lot of recognition in terms of political identities for indigenous peoples and Afro-Colombian communities, so many cases of prior consultation and the right to territory, but that's not the case for peasants, right? So until now, the court has neglected most of the times the claims that peasants bring to the court in terms of land. So they are recognized as victims, but the right to the land and territoriality is not recognized to peasants. We would expect some changes now that Colombia has ratified the UN Declaration on Peasants' Rights, but the court, which is progressive activism, tend to deny all those claims by peasants, which are usually grounded in this idea of peasants as landowners and not as agrarian workers. And then you can see also a very interesting opposite trajectories in terms of mobilization. So you could see at the beginning, after the 1991 Constitution, like we have like all these new frameworks. So the social mobilization processes for indigenous peoples and Afro-Colombian communities were so dense with tons of organizations and NGOs and different alliances, different networks. And that was not the case for peasants. And now you're actually seeing how they're like converging. So less dense networks and less alliances for Afro-Colombians and indigenous, and way more dense mobilization for peasants. So if the explanation makes sense, you would expect also a shift in the outcomes if mobilization is actually a good predictor of how the court responds to that.
Thank you. Wow. You made it in 6 minutes. Thank you.
Hi, everybody. I'm also very thankful to have the opportunity to talk about this project here. My name is Ana Cortes. I'm originally from Brazil. I'm a PhD candidate at the University of Coimbra, Portugal, carrying out part of my work on my PhD here at Law Transform. But in parallel to my work on my PhD, I work on this project as a researcher affiliated to the Christian Michelsen Institute. I'm working on the case of Brazil together with Lara, who I guess most of you, if not all, know. For the case of Brazil, we are working with 3 different main groups: indigenous communities, landless workers movement, and Quilombola communities, which are residents of communities formed by Black persons who were enslaved and escaped resisted slavery in Brazil. We decided to divide our work and at first take a look of the cases of involving each of these groups separately. And we started with the Quilombola communities. The reason for that is that there are many more cases involving indigenous communities than the other 2 groups. And then if we had chosen to look at all of them at the same time, we would certainly miss some specificities. So for the general project on the case of Brazil, we have mapped out the legislation about land rights in Brazil and how this legislation addresses the rights of these groups. What are the differences in the legal regimes and in the Brazilian legal system? We have also worked on a timeline. We all have. In our case, it included when laws were issued. It includes the Supreme Court cases we are working with and the different administrations in Brazil, because there are also very important decrees and changes in the land regularization procedures that came from the president's, the executive power. So now I'm going to focus on the Quilombola community cases for a while. When we look at the decisions from the Federal Supreme Court on Quilombola land rights that actually addressed the merits of the cases, we only have 4 of them. All of them are abstract constitutional review cases involving collective land rights. We can make a few remarks about these cases / the decisions. In this, we have identified identity-related arguments in these cases, and that's why we're also working with literature on identity. A very generous suggestion from Tatiana that was spot on. That's the beauty of working on a collective project like this. And some examples are disputes over the concept of Quilombola. What is a Quilombola community? And this we see both in court cases and political context. And another example, the differences between Quilombola land rights and indigenous land rights recognitions. All of those decisions we are working with were issued in favor of Quilombola community land rights, but there are also other factors to have in mind. For example, the long time cases can take to be decided, and cases from other stances against Quilombola land rights. In these cases, there's also a plurality of actors, both taking the cases to the court or acting as amici curiae. if we focus here on the actors that took cases to the Federal Supreme Court, there are official government actors, political parties, including a conservative political party filing a case against Quilombola land rights, and a Quilombola civil society organization. That is especially important in the context of Brazil, considering the selectivity of the Federal Supreme Court, and I have one of my main references on that here, Juliana Cesare Alvim. Until very recently, civil society organizations would not be accepted taking cases to the Federal Supreme Court. Of course, they could associate, work on a case and ask another actor to file it, but they wouldn't be there. Their names wouldn't be there as the one that took the case to the Federal Supreme Court. In the last year, this possibility has been recognized to a few organizations, and the Quilombola Community Organization was actually one of the actors taking one of the cases we are working with to the Federal Supreme Court. This case was actually about the COVID-19 pandemic and the effects to Quilombola communities, and vaccination and so on. But it had a very interesting strategy that was claiming for the suspension of all lawsuits claiming Quilombola community land rights until the end of the pandemic. I guess this, I don't have time to talk about all the cases, but these are some important points I can make about the case of Brazil.
Hi, I'm Jackie Dugard. I'm from South Africa, but I work at Columbia University in New York, and really super excited to be part of this group. Not only because it's just a fantastic set of scholars and activists, but also because it brings together two strands that I've been working on for about 20 years. The one is courts in the poor, and I met Siri Galoppen in 2004 in a project she was doing on courts in the poor. So this is really a fantastic synergy for me. And then I've been teaching property law at Wits University in South Africa for 10 years. So it's really, for me, a very interesting nexus of these issues. And so obviously in South Africa, as in all of the countries we're talking about, land is very key. And in South Africa, we have, of course, massive colonial apartheid dispossession of land. And this is one of the key questions that we sought to resolve in the transition, the formal transition away from apartheid, which resulted in a change of the regime in 1994 and what we call the final constitution in 1996, of which we have a property clause which has extensive land-related provisions. So my case in some ways is easier than many of the others because we have very clear frames. We have three key pieces of legislation that relate to land and property rights for disempowered, historically disadvantaged, i.e. dispossessed groups. One is the Restitution of Land Rights Act. The second is an extension of Security of Tenure Act. And the other one is a Labor Tenants Act. And so these acts together have jurisdiction on the land claims court. So now I'll just do a segue onto the courts part of this, which is that in transitional justice theory, there is obviously a lot of discussion about the judiciary when you're moving from transformation from an authoritarian regime. And in South Africa, we had a lot of debate about how do we approach the judiciary? The judiciary in South Africa, I mean, South Africa is amongst the very many extraordinary features of South African apartheid was the buttressing of law. Everything was legalized under the apartheid legal order. So the judiciary was part of the apartheid machinery. So the question is, what do you do with an illegitimate judiciary? And there were many debates about how to resolve this. And the prevailing outcome was we should have a constitutional court, create a new constitutional court that could act as a transformative lodestar to pull the judiciary in a transformative direction and to try to move away from the apartheid past. And we very much understood that land as a key issue, that there should be a land claims court. So a specific court charged with dealing with land claims. So the land claims court has specific jurisdiction over these 3 pieces of legislation. So what is interesting about the South African case from my perspective is that the frames analysis, which is very key, as we've heard so far, whether you bring a claim as a peasant, an indigenous group member, or a Black or Afro-Colombian or Afro-Brazilian, etc. person, is less relevant in the South African context. The framing, my research has shown that it doesn't matter whether you're dealing with a labor tenants claim under the Labor Tenants Act, whether you're dealing with an extension of Security of Tenure Act with as farm dwellers resisting eviction, or whether you're dealing with restitution of land. You get pretty much the same outcome regardless of the frame. So my hypothesis is the framing is less important. My hypothesis is what is key in the South African context is the site. So, and here we have, I think, something that for me is pretty interesting. One would think that the Land Claims Court, as specifically set up as a post-apartheid institution to deal with land claims, specifically to act in a transformative way, you would think that would be the most transformative court. But unfortunately, that is not the case. So counter to the hypothesis, what my research has shown so far is that the Land Claims Court is possibly the most conservative. And then, so what I'm looking at, my method is to take the 78 cases that have gone to the Land Claims Court that have been appealed. And then I'm looking at the outcome of the same case in the Land Claims Court, the Supreme Court of Appeal, and the Constitutional Court. I therefore end up with only 15 cases, so I can dig quite deeply into them. And just from the initial research, it looks like there is a serious problem with the Land Claims Court. And I wouldn't be the first person to point this out. But what I'm interested in is to try to understand. So my project, perhaps more than anyone else's here, is really about courts. And it's trying to make some arguments and analysis around transitional justice theories in context. So thank you.
Well, I'm working on the case of Guatemala together with Ana Braconnier, and we have been working with different collectives of indigenous lawyers in Guatemala who litigate collective rights claims to land. Guatemala is about 40% indigenous. It has one of the most unequal land regimes in the Americas. It has a very weak multicultural order, so there are elements in the 1986 Constitution and international law, particularly ILO Convention 169, which have been used to litigate collective claims to land rights for indigenous peoples. But private property is extraordinarily central to the entire legal order and the constitutional order. So we've been trying to we have put together a database on land rights cases, trying to look at 2 contrasting frames that have been used to litigate territorial cases for indigenous collective rights claims to land. One is free, prior, and informed consent, which has been the most frequently used frame for litigation. And we have 29 cases of free, prior, and informed consent. And then there are a group of cases that are trying to litigate for restitution of land which was effectively stolen through colonial expropriation processes over subsequent decades. Many of those claims date back to the late 19th century when those lands were stolen from indigenous communities. Yeah, what we're developing is the database and analyzing those cases according to this matrix, which we haven't quite finished doing, but we have a smaller universe of cases than many of the other countries here. And so one of the outputs that we hope to have from this is that database for the organizations who are litigating that we're working with. And we're also working at the moment as one of the first papers that we're trying to develop as part of the project of contrasting 4 cases, right? So 2 of different frames. So 2 litigated according to free, prior, and informed consent, and 2 ancestral rights lands claims, trying to take a most and a least successful case just in terms of did the claimants get what they wanted in court, or did they get some of what they wanted in court? And trying to think also about these diffuse effects and outcomes of the cases. So sometimes even the case that you lose has more positive diffuse effects and outcomes, or the case that you win because, for example, in terms of recognition, the court says, yes, these are Indigenous peoples. Yes, they do have a right to free, prior, and informed consent, but as happens with many of the free, prior, and informed consent cases that we're looking at, the actual effects of that recognition are very minimal. And so that's what we've been doing for Guatemala, where there's very, very little traction in terms of policy shift. On land, there's been, in the period that we've been working, kind of, as Shiska was saying to us earlier with the columns of Guatemala, in the 3rd column, we've had terrible co-optation, state capture of the courts, and that's also feeding into this timeline of kind of when we had more positive, at least recognition in the courts and what's happening now, at the same time as land grabs, evictions, criminalization of Indigenous land defenders. So I'll stop there. Thank you.
Thank you, Anna. And once again, thank you to Law Transform. So I'm Namita Wahi. I'm at the Center for Policy Research in New Delhi, and I started and head the Land Rights Initiative. And as I explained in the earlier panel, both are basically just me right now. Speaking about plural land regimes, they are an ubiquitous feature of post-colonial societies, and that is because the nature of colonization inherent within that is the appropriation of natural resources of the colonized country by the colonizer for the economic and social development of the colonizer. And the world can essentially be divided, of course, there's a lot more nuance to this, but broadly can be divided into settler colonies and conquered colonies. And settler colonies like the ones in North America, Australia, and so on, were essentially where Indigenous communities were pretty much decimated, and the colonizer was able to appropriate resources in a more systematic manner. In conquered colonies like India, the Indigenous populations were not decimated, and once the process of colonization ended, the colonizer left, and the Indigenous population then took over. So there was a process of intense contestation as the the conqueror tried to erase the existing legal frameworks and resistance by the colonized people. So if you look at the history of India, India was essentially ruled by a corporation, the East India Company, from 1793 to 1858. And then 1858 is when the British Crown took over, from 1858 to 1947, till when India becomes independent. And during this 200-year history, the colonial state is only, the focus of the colonial state is to maximize revenue for the British East India Company and then the British Crown. And essentially, they divide all land under 2 legal regimes. There is revenue land, so agricultural land from which peasants would produce and then pay revenue to the British state, and forest land, which is where Indigenous communities in India were mostly residing. And Indigenous communities in India are called the scheduled tribes. And there are 750 tribes that are recognized as Indigenous in India. They constitute 8.6% of the population of India today, They were 7% at the time of independence, so their percentage relative to the population has actually grown, which indicates both greater recognition of communities as indigenous tribes, but also improvement in their conditions of health, education, and which have allowed them, to become a greater percentage of the population. So the colonial state did this erasure through what I call displacing laws. So there were 4 sets of laws. There were the land acquisition laws, by which the state could acquire any land for its purposes. And if it was privately owned land, like agrarian land, then at least some compensation was due, but only to the property holders and not to the tenants and so on. Or it could do it under, but if it was commonly owned resources, and much of India was common land, then there was no compensation due. But because, you can't, they were not able to remove the population from the common lands entirely, so there was always this contestation that went on. The second set of laws was the forest law, starting from the forest policy of 1868, where basically first they recognized the rights of indigenous communities. Gradually, these rights became privileges and concessions, and then they completely derecognized and illegalized the forest dwelling communities. So over 100 years, this happened. Cut to 1947, as I said, India indigenously drafted its constitution. It was a transformative constitution because all Indians overnight became went from subjects to being citizens. And in 1950 itself, India was a pioneer in introducing in the constitution special protections for indigenous peoples in the 5th and the 6th schedule. So the 5th schedule covers 10 states in peninsular India, and the 6th schedule covers 4 states in the northeastern part of the country, which grant significant autonomy over land and natural resources in tribal-dominated areas. Now, the Land Rights Initiative, for the first time, we created a map of the scheduled areas, and I can now tell you that 13% of India's geographical areas, scheduled areas. So India has the largest indigenous population in the world, and also a significant percentage of its land under indigenous. Now, in terms of studying the role of courts, generally indigenous communities in India have not, and that's interesting because we've done work on health rights litigation, water rights litigation, and that is not the preferred strategy of indigenous communities. In fact, even in the project on the right to water, as my paper pointed out, that in fact the human right to water may have empowered citizens' access to right to water, but has actually disempowered rights of indigenous communities, partly because the framing of the indigenous communities of land, but also water and forests, is not a property right claim. It's really that of Jal, Jungle, Zameen, water, forest, land, which is part of an indivisible ecosystem. And as a result of which, the separate recognition of these rights as land rights, water rights, and forest rights actually deprivileges their understanding of rights. But for the purposes of this project, we looked at the court cases that have actually been brought. And my initial starting hypothesis was to study the regime under the 5th schedule and under the 6th schedule to see whether different legal framing in the constitution was impacting the way these claims were being brought. But as I dug deeper, and that brings me to the constitution was progressive, but it was status quoist in the sense that it retained a lot of the architecture of laws and at the statutory level. And I realized as I was studying through the cases that, basically it's the statutory framing that makes a lot of difference to the way that these claims are being brought. And so just to conclude, first of all, these legal struggles, in order to bring the case to court and then to translate into successful action on the ground, it takes almost 20 to 25 years. And as a result of which, the courts are really not the preferred mechanism. And it's not the framing that matters so much, but temporality, networks, the other actors at play, other interests at play, where, environment and climate justice concerns are also central, as opposed to just the claims of indigenous communities.
Thank you, and I'm happy to be here. My name is McConan. I am an associate professor of law at University of Buffalo in New York City. So I look at the Ethiopian case within the PluriLand project framework. I'm going to share with you basic findings I have so far. I have looked at about 100 cases decided by the House of Federation, which is the Constitutional Court of Ethiopia. the equivalent of a constitutional court in Ethiopia. That would be cases decided after 1995, actually, when the institution was created. And about 60% of these cases are about land. And probably about 20% of the remaining 40% would be indirectly related to land. What that means is basically every 6 cases out of 10 cases are about land. And to understand the legal landscape in the country, we need to look at the land rights or land cases. Unlike the findings of most of my colleagues, these cases are individual in the sense that they are about property division, land division, following disputes about divorce, rental or market exchanges, informal market exchanges, settlement, informal settlement. So litigation in the sense of social legal mobilization is not really common. It is hard to find. So I haven't seen any case involving litigation as a strategy for broader social or political change. So one of the questions would be, why is litigation as a political mobilization or social mobilization is rare? An answer could be the history of the country, that before 1991, it was a socialist country where land was nationalized. And there is more or less equal distribution of land holding across the country. So that could be the lack of using law or courts as a means of broader social justice or social change, right? Most of the cases I've looked at are actually pro se, meaning the individuals brought the cases themselves. They're from across the country. Some of them have legal representation, but by what you may call as rural lawyers, lawyers who are based in rural societies. So you don't really find political inclinations or a political agenda or an ideological persuasion in any of those cases. One interesting exception is with NGOs and political parties using social media reports, human rights reports, and things like that, or medium of that sort, to galvanize support or opposition against the government. And most of these reports frame displacement or land disputes in terms of ethnic discrimination. So ethnicity or cultural discrimination through the political processes, and again, not as litigation or legal process. So the last point, or what I'm struggling is, or what I'm trying to figure out in the next step, is looking at marginality intersectionally through within the context of family, gender, and as well as generation, rural-urban change, and through market, renters and sharecropping and sellers and buyers. If we can actually identify broader struggles or distributional questions from these individualized micro litigations, and I think there is a point to be made there. Thank you again.
Thank you all. We have a little bit more than 5 minutes to open the ground. So again, please, the line in that mic. And if you have any questions or comments, they're welcome.
Okay, thanks for a great panel. I'm impressed at the variation in cases and in context. And my question, I guess it goes to the PI, but it goes to all of you actually. When you choose cases that are post-colonial, post-apartheid, when independence goes from the 1800s into the 1990s, when you have large indigenous populations, small indigenous populations, I mean, there is a huge variety in context here. And you also focus very differently in your empirical approaches, either through court cases at different levels or more qualitatively. So my question is, how do you draw comparative findings? How do you, when you do theory building, how do you use your findings to inform existing theory? I know this is very complex. So sorry if I'm disturbing you.
Great panel. I'm Shubho. I'm from McGill University. My first question, I have two short questions. First is to Namita. I'm sure you have a lot to talk about Manipur and land as an underlying factor for ethnic conflict there. Now, the Kukis have scheduled tribe status, but there's a lot of rhetoric from the Métis side about how they are more indigenous than the Kukis, and how, who are the original inhabitants, and here we are seeing a conflict over that issue. So do speak about that. And I also have a question for Jackie. You suggested that the land claims court in South Africa was actually less transformative than you expected. I was wondering if your findings suggest why that is the case. Thank you.
Thank you. This was such a great panel. I'm really appreciative of everyone's amazing inputs. My name is Talia. I'm still affiliated at the University of Massachusetts in Boston. So my entry point to this debate is from climate change and the energy transition challenge that will put ever more pressure on the extraction of critical minerals, especially in the Latin American region as well. So earlier, Rachel mentioned that in some of the cases, you are not expecting, in looking and assessing the potentially transformative outcomes, in some of the cases, you are not expecting legalization in forms of policy shifts. So I'm particularly concerned with the attempts to regulate the free, prior, and informed consent in some countries. So how, for you, and also in Colombia, for example, how would that factor into the assessment, or how would you gauge those attempts to of regulation, of new regulation, into the project and into your methodology? Thank you.
Thank you. We have 5 minutes left, so please. No, it's 3 minutes, yeah, actually.
Do you want me to answer? Ellen, yes, Ellen, I understated. I'm impressed with your case selection. We're not trying to do something explicitly comparative across the cases. And I think that, but the project, the questions of the project, and the way that we're thinking about some of the findings that you've heard is informed by comparative sensibility, right? So that's probably the best answer that I can give to you in terms of our case selection. As such, there are kind of subgroups within it as well that are coming up with, yeah, interesting. I'm not sure how we're going to draw comparative empirical findings as such, but I think that we're going to have things to say about the theoretical debates around land and land rights claiming that's going to come from this rich diversity of cases that you've heard today.
Thank you. Yeah. So I think there were 2 questions. On Manipur, so just to give context, this is a state which for the last 3 months have been in a state of civil war between 2 communities, the Kukis and the Métis, but there is a third community, the Nagas, which are also there. Manipur is not one of the states that comes under the scheduled areas, and that also brings out the issue of the fact that indigenous people are there in all the states of India, and yet not all of the areas have, states have areas that are demarcated as scheduled areas. I think, to get into the fault lines in Manipur, it would be a long debate, but just to say that it's also a border state, and the Kukis have ties with Myanmar, and there's involvement of poppy cultivation that has been going on, where indigenous land has been grabbed, which is also being funneled. There's involvement of China. So there's a lot to the Manipur crisis that goes beyond, but it goes to questions of identity, land grabs, dispossession, and the things that we've been discussing otherwise in the panel. Oh, and on climate justice, I think the interesting thing is that, much of the struggle for rights of these communities has been framed either in the form of existing land legislation and so on, and the push on the forest, but seeing them together as a composite, indivisible ecosystem that is important for climate justice hasn't really filtered into the legal terrain in India so far.
And just very quickly on the land claims court, yes, of course, I need to look and have certainly some ideas around that, about why. So what I will be looking at, and this follows up on previous research I've done in terms of socioeconomic rights cases in the High Court, Supreme Court, and Constitutional Court, looking at why you would have those outcomes. Yeah.
So we finish here, and we invite you to keep posted on next year publications. And thank you very much, and see you in the afternoon.